So when I meet with a client for the first time, one of the things that we go over, obviously, is what happened to them, and they tell me their story, what happened at the hospital, what happened at the clinic, and we talk about that. But the next thing that we need to talk about are what are the elements of a successful medical malpractice case? What must a client, the victim of the malpractice, and their attorney prove in court to establish a winning case? Well, this video will talk about that. So there are elements of professional negligence, medical malpractice, that are defined in the law. And if you look in the law books, if you talk to judges and attorneys, you may see it described in a little bit, a few different ways. I have my own way of thinking about it. This may or may not match what you've heard from others, but this is the way that's worked for me over the years. There are generally three things we have to prove. This is a simplification. There are a lot of things we have to prove in one of these cases. But this is a good general framework to start that conversation. The first thing we have to prove is, did a medical provider do something wrong? Was there a medical error committed? Now, a lot of clients that come to me for the first time, they think that's the first and last thing they have to prove, but actually it's just the first step. And it's actually a little more complicated than just saying medical error, a mistake. The legal definition is quite a mouthful. It's called, the measuring stick is, did the medical provider fail to meet the minimum standard of reasonable medical care? Mouthful. But it's educational. It means that there's a minimum standard, not what a perfect doctor would do, say, but what would the minimum standard be, and did that doctor or nurse or medical provider reasonably comply with that? And medical standards of care are, there's no big, huge billion-page book where those are located because the circumstances can wildly vary, So we have to hire medical experts and engage what the standard of care might be in a specific situation. We have the burden of proof to show with medical expert evidence that the medical provider deviated from the minimum standard of reasonable medical care. And it's an industry-accepted standard, not one that we just make up, but one that we might find in the medical literature, in the textbooks, that sort of thing. Now, that's number one, the threshold question, was the standard of care violated? Number two is damages or injury. Was my client injured? Physically, permanently injured in some very serious way? Did they pass away? Am I representing an estate? Are they in a wheelchair, or do they have a very large medical bill? Are they unable to return to work and support their family? Very serious injuries like that. We'll talk more about how we think about damages in a subsequent video. The third thing that we have to prove is sometimes the hardest one, and we call it proximate cause, causation. I like to call it cause and effect. Let me explain. Did the medical provider's error, element number one, directly cause, element number two, the injury? And that sounds very simplistic. In a car wreck case, if they ran the red light and they T-bone your car and you've got a broken leg, that's pretty easy, right? In medicine, it can be more complicated because the patients come to the hospital or to the clinic with medical problems that are ongoing in the first place. Otherwise, they wouldn't be seeing a medical provider. These disease processes may have bad outcomes that are unavoidable. We can't always see inside the body and tell exactly that cause and effect link. So it can be tough. And we use medical expert evidence for this. We look through the medical records. Maybe we look at an autopsy report. We have to have scientific evidence, medical evidence, and again, we bear the burden of proof. Now, there's an important general thing to think about with these three elements. We have to prove all of them. Just having number one, did somebody do something wrong? That's not enough. We have to have 1, 2, and 3. That's where you build your three-footed stool that can stand up in court and maybe win. Well, I hope this has been educational or informative in some way. If you want to learn more, give me a call, email me. Use my website to get my email address. Just send me a note. I'd love to talk about it more.